Who gets the house in your divorce in Washington state?
Your lawyer. Just kidding. Sort of.
Anyway, these are the factors our firm believes judges weigh most heavily. They're in order from the most important to least. First factor, enforceable agreement. If the parties enter an enforceable agreement regarding the house, the judge almost always adopts it. Enforceable agreements can take a bunch of forms. Examples include prenuptial agreements, post-nuptial agreements, which are prenuptial agreements signed during the marriage, separation contracts, which are contracts signed when the parties informally break up, and settlement agreements, meaning agreements signed during the divorce or made in court on the record. So, whoever you've agreed should get the house probably will, assuming the agreement is signed or on the court record. This is one instance where you get to tell the judge what to do. You probably shouldn't make it a habit. Second factor, one party's separate property. Courts usually award each spouse his or her separate property and divide the community property 50-50. If the house is entirely one spouse's separate property, that person almost always receives it unless the parties agree otherwise. If you want to learn more about how Washington determines whether property is separate or community, we have a free article on our website. Third factor, partly separate, partly community. Often the house is partly separate property and partly community property. In that scenario, the spouse with the separate interest is more likely to receive the house, though the outcome is less certain than if the house were completely separate property. For example, the down payment may have come from one spouse's separate pre-marriage funds, but the mortgage might be community debt. The party who paid the down payment with separate pre-marriage funds is more likely to get the house. If that's you, it means you get to kick the other side out of the house. Eventually, and really it's the judge who's kicking the other side out. Fourth factor, who can afford? Courts try to avoid awarding the house to a party who can't afford it. This is especially true when the mortgage is in both parties' names. If the mortgage is in both people's names, failure to pay would hurt both people's credit scores. This isn't as likely to be relevant for mid-length or long marriages because the lesser-earning spouse usually receives child support and spousal maintenance, or alimony. That often makes the home equally affordable to either party. But in dissolutions of truly short marriages, there tend to be no children or maintenance. In those cases, the higher-earning spouse generally receives the house unless it's the other party's separate property, or the court forces the parties to sell it if neither party can afford it. More on that later. Patience, it's a virtue. But maybe if you were more virtuous, you wouldn't be in this mess.
Too far. That's too far. That's too far.
Okay, you're right. But you gotta have a sense of humor. You gotta laugh to get through this, you know? You should put a joke in the comments section, but not about me. Maybe about somebody else. Fifth factor, keep the business running. If one spouse runs a business closely entwined with the house, that person is likely to receive both the house and the business. An example would be a spouse who runs an adult care facility from the family's spare bedrooms, or maybe a daycare. Sixth factor, keep kids in the family home. If the parties have kids together, judges try to keep the kids in the former family home. This is for the children's comfort and emotional stability. Net result, the party who receives primary care or custody is likely to receive the home as well. Courts especially emphasize this factor when deciding who gets the home during temporary orders. It's listed here as the sixth factor, but it probably rises to the second factor when judges or commissioners are making temporary decisions. Temporary orders, by the way, are something a party can request during the pendency of the case. The average divorce takes almost a year.
A year? Are you kidding me?
Come on. You knew how long it takes.
I thought it would be funny. You know?
As you can probably imagine, that's a long time to wait for certain kinds of relief. Parties sometimes need temporary orders to help get them through that year. Seventh factor, avoid an additional move. Courts also err on the side of minimizing disruptions to the parties. If only one party is currently in the former family home, he or she is more likely to receive it. Doing so avoids an additional relocation. Additional notes. Note number 1, courts rarely force to sell. Historically, Washington's courts have been extremely reluctant to force the sale of real estate. This makes intuitive sense. People become emotionally attached to their homes and land. People like their patches of dirt. Selling real estate also comes with transactional costs of about 8% of the sale price, excluding federal income tax. Federal income tax applies to the extent that the parties don't use the proceeds to purchase a new primary residence. If they don't roll the funds into a new home, it can sometimes increase the cost of selling the home to over 35% of the sale price.
Wow.
Wow was right. That's a pretty expensive way to divide property. Better to award the house to one of the parties and avoid the transactional costs if possible. Courts can nonetheless order the sale of the home when the parties agree to it. Courts can also force the parties to sell the home if the court believes it's justified because of the limited alternatives to fairly dividing the parties' property. If you're curious what a fair division of property looks like, our website has an article and video on the basics of property division. Note 2. Valuing the home. At a contested trial, the court typically needs to place a value upon the home if it's community property. Valuing how much each party is awarded is how the court figures out whether the awards are fair. If the court doesn't have a value for the house, it'll probably have to have it sold so the parties can evenly divide the proceeds. As mentioned, selling the house is bad because of the transaction costs, so give the court a house valuation to use. High standards apply to real estate valuations in court. Tax assessments and lackluster analyses are inadmissible to prove fair market values, and comparative market analyses come into evidence only under certain conditions. This might mean automated estimates from websites like Zillow and Redfin are also inadmissible. Picky, I know.
Judges can be such a pain. Sort of.
In case any judges are watching this, the gold standard for valuing a house is a fair market appraisal from a licensed appraiser. Washington courts have allowed parties to testify about their opinions on the value of assets, but those cases appear to have stretched evidence rules regarding normal people's testimony and expert testimony to reach that result. These cases are also older than the current version of Washington's evidence rules and might be outdated. Best to get a licensed real estate appraiser. Note number 3. Temporary orders supposed to be irrelevant at trial. The law prohibits temporary orders from prejudicing a party's arguments at trial. That means a trial judge shouldn't consider who's in the former family home if the spouse gained that exclusive use through a temporary order. This is because temporary orders are issued quickly and without the procedural safeguards available at trial. Many trial judges are unaware of this law.
Wow. Who's ticking off judges now?
I'm making a valid point. If you want the court to know about this rule, make sure to mention it. You should put it in your trial brief and closing argument. That's it. Hopefully this was helpful. Our firm believes in making quality legal information available for free online. For more, visit the resources section of our website, genesislawfirm.com. From all of us at Genesis, best of luck with your family law matter.